There are some core documents that every estate plan needs. The first is a will. The will is your statement of what you want to happen to your assets at the time of your death. Who do you want to receive them, and how do you want them to be received? Who do you want to be the executor of your will and manage the probate of your estate once you have passed away? All other documents that are necessary are a medical power of attorney, which governs what happens while you're still alive, but manages your medical situation if you're not able to make decisions. We like to include something called a HIPAA release with that. That's the document that every time you go to the doctor's office, they ask you to sign. Who can we give information to about your medical situation? So if you're going to sign a medical power of attorney, giving someone else the authority to make medical decisions for you, you also want to sign a HIPAA release so that they get information about your medical situation to be able to make good decisions. Another important document is a legal and financial power of attorney. It can be the same person as the person you've named to be your medical power of attorney, or it can be different, but you name that person to make legal and financial decisions for you if you are incapacitated, or even if you are not incapacitated. It allows someone else to help you out in those situations. The final document that is a core one for your estate plan is a directive to physicians. Some people call this a living will, but the purpose of this document is to direct your family and your loved ones and your medical providers to your wishes if you are at the end of your life. Do I want to be kept comfortable? Do I want to be kept alive on machines and artificial life support? This is where you tell your family and your doctors how you want that situation to be handled if you are facing it at the end of your life. The biggest mistake that people make with estate planning is assuming that they don't need an estate plan. A lot of people assume that things just happen automatically. I want my wife to get my estate if I pass away, or vice versa. Or I want my kids to get my estate if I don't have a spouse or if both of us are gone. Those things do not happen automatically. If you don't have a will or a trust, there is a plan. The state of Texas has a plan for you. However, your family will have to go through an extended probate process to make that plan happen. So while you may not have a will and you just want your spouse to get everything, that may happen, but your wife will have to probate your estate. They also have to make sure that the court feels comfortable that there are no other heirs out there that we don't know about. So there's also a thing called a determination of heirship that has to happen before your estate can be probated. That complicates the situation. There is a legal process. Another lawyer is appointed to represent the unknown heirs. It takes time. Someone has to come to court to testify to say that, yes, I know they were only ever married to this one person, and I know that these are their only children. But this is a complicated process for something that should be really easy. If you have a will, all of that can be avoided and your wishes can be carried out easily. When you create your will, you will choose an executor. A lot of people will choose their spouse as the primary executor for each other, which is just fine. Once we get beyond spouses, now we have to decide who else would we name as an executor. Sometimes that's an adult child, sometimes that's a friend or family member. I would always recommend that you pick someone that is going to be as neutral as possible. If you think that there's going to be fights among your family members, even though you've said what you want to happen after you pass, you also want to try not to name co-executors for handling your estate. If you name two people to work as an executor, they have to be on the same page on everything. They have to agree on everything. And sometimes in this situation, they're going to have different opinions about how things should be handled. give one person the primary right to handle everything. They may keep everyone else involved and informed, but don't set your executor up for failure by making it difficult where they have to get someone else's approval for everything. An executor's job is to essentially shepherd the case through the probate system. They find the will, they file the will with the court, and file an application for probate. Then their job is to gather all of your assets, discover all of the liabilities, and once they're appointed to be executor, now their job is to distribute any assets after they have paid all the debts of your estate. A lot of people want to understand the differences between a trust and a will. A will simply states, at the end of my life, once I have passed away, I want my assets to be given to certain people. Sometimes that will can provide for a trust to be created upon that person's death. For instance, we create contingent trusts for minor children in the wills that we prepare, so that if you are a parent of young children and you're concerned that if you pass away before those children are old enough to manage any inheritance that they get on their own, that will creates a trust for the benefit of those minor children, and a trustee is named to manage those assets until your kids are old enough to do so for themselves. A lot of people don't understand that a child under the age of 18 cannot manage their own inheritance. So you can leave a bunch of money to a 15-year-old and they can't get it till they're 18. So you want to make sure that you have created a contingent trust and someone is named as trustee so that that money can be used for the benefit of your child, even if they haven't become an adult yet. A trust is essentially like a company that you're creating, and you're transferring all of your property to that company, and it's the trust of your family, the company for your family. The trust then holds all of the assets in the trust name. So your house may go into the trust, a business may go into a trust, accounts may go into a trust. The benefit of putting all of your assets in a trust is that this avoids probate. The trust owns the property, so once you die, nothing needs to happen with a probate court because the trust already owns the property, and the trust rules determine how that property is going to be distributed or whether it's going to be distributed. Sometimes the property remains in the trust, but there's a new beneficiary once you've died. That helps you avoid probate. It also helps you avoid potential estate taxes. It can protect your assets from creditors. It can protect your assets from the government if you or your spouse need long-term care through Medicare or Medicaid. A trust can also protect assets from someone's bad decisions. For instance, sometimes parents will create a trust for the benefit of their adult children once the parents pass away, and the trust is managed by another person who makes decisions about whether to distribute money to the children. If you have a child who is not good with money, who is a gambler, who has substance abuse issues, you may want to protect them from themselves and not allow them to have access to a lot of money that they might spend in inappropriate ways, and they might not have that money to take care of themselves. If you have a large estate, you own a lot of different property. If you have property that's very high net worth, over about $12 million, having a trust is crucial. Once you have property worth over about $12 million in the current day and age, then you could be subject to estate taxes if you don't have a trust. Also, when you have numerous properties, especially if they are located in different states, if you don't have a trust, then you have to probate the estate in each of the states that you have property in. That can be a huge mess for your heirs. So having everything in a trust, owned by the trust, that trust can be located in Texas and can own property all over the country. And then you avoid probate for those properties. If you don't have a trust and you pass away, your estate is going to be probated in Texas. Now, thankfully in Texas, it's not a super long process. It's not super expensive, but it's much easier if you do have a will. If you've got a will, it's a pretty straightforward process. It can be handled in a matter of months. It is not incredibly expensive. It's much better if you don't have to handle probate or your loved ones don't have to handle probate. But again, it's doable. If you don't have a will, that extends the time frame quite a bit. It also makes it much more expensive because there's many more things that have to be done in your probate if you don't have a will. We have to identify your heirs. We have to appoint an administrator of the estate. Sometimes, depending on the situation, that probate and the administration of your estate may need to be court supervised, and that is very costly, time-consuming, and causes a lot of family drama. If you have any questions about estate planning or probate, we'd love to talk to you. Please call us at the DeFord Law Firm.